Hello viewers. So Pratik has discussed an important step in judicial intervention, which is Section 11 of the Arbitration Act, and that is to deal with the appointment of arbitrators. Now, I am going to take you through a couple of other important intervention points, which is also prior to the arbitration proceeding actually kicking in. Section 9 of the Arbitration Act is an important process which deals with interim relief, where a party may approach a court of law prior to the arbitration proceeding, of course, to seek certain interim reliefs, which may be in the form of securing its claim amount, preventing a party from disposing of property or assets, sale of goods, etc., completely depending upon what the nature of the dispute is and what the subject matter of the dispute involves. Section 9 of the Arbitration Act is not only looked at prior to the arbitration proceedings commencing, but it could also be during the arbitration proceeding or after, just before the enforcement of arbitral awards. But in general and practice, you will more often than not see that Section 9 petitions are filed prior to the arbitration proceeding actually kicking in. There is a rationale for this because after the amendment of 2015 to the Arbitration Act, Section 9 and Section 17 have both been brought on par, wherein an arbitrator can also now grant interim reliefs, which are akin to the reliefs that can be granted by a court of law. So the process during the arbitration itself, the parties would obviously approach the arbitrator under Section 17 and not a court under Section 9. Though that is still open to the parties, and there has to be therefore an egregious default from the arbitrator for the party to go back to the court during the arbitration proceeding actually existing. Now, where does a Section 9 petition begin? It begins when a party comes to a lawyer with its case and says that, look, I have a claim amount or I have a certain dispute with a party. There is an arbitration agreement in place. And now you advise me on what to do. The first step, like Pratik has already discussed, would be to issue the notice of arbitration, asking the other party to arbitrate. Now, in that intervening phase between the arbitration notice, between the arbitral tribunal being constituted and the arbitration proceeding starting, there may be a chance where a party feels that, if I do not get certain reliefs in terms of interim reliefs from a court of law, the other side may dispose of my assets, may actually take steps to sell its property, all done to frustrate the arbitration proceedings and ultimately the claim or the award that may be granted by the tribunal. Essentially, this is to prevent the entire process of a Section 9 is to prevent the arbitration proceedings from really becoming infructuous or from the eventual arbitration award or the arbitral award when it's rendered from that being a mere paper decree. That is when a party should consider a Section 9 petition. Now, as a lawyer, you will advise your client on Section 9 petitions in possibly two instances. One is, of course, like I've already said, that when a party feels that the other side may be in a position where they have poor finances or that they may take steps to frustrate the arbitration or the ultimate arbitration proceedings or the award, that is the first time that you will consider filing a Section 9. The other could actually be as a pressure point to actually bring the other party to the table. If your client feels that they have enough evidence or documentary proof to show that the other side is in a financial mess or could actually dispose of assets, then it may not be a bad idea to consider filing a Section 9 petition before a court to seek certain interim reliefs. Whether or not these interim reliefs are actually eventually granted by the court may not really be the consideration. It may only be the real consideration may only be that the other side may feel that these proceedings could go either way, and it's best to talk and enter into some sort of negotiations at the beginning with the counterparty and close the issue. So Section 9 petitions therefore have two real roles. One is to secure the eventual arbitral award, and second, to essentially try and see if there could be an amicable settlement. Prior to actually instituting a Section 9 petition before a court, what must you as a lawyer be looking for? What are the ticket points that you should be looking for? One, you should ask your client to provide enough documentary proof to show that the other side is, like I discussed, is either taking steps to frustrate the arbitration award, is in a financial mess, or they are doing things which will actually result in a violation of the contractual terms so vital to the contract that it cannot wait to go before the arbitration proceedings before an arbitrator and be decided by the arbitrator in a Section 17. Essentially, what you have to show in a Section 9 petition is that there is significant urgency which cannot wait for the arbitration proceedings. Now, there are few small things as lawyers that you could do to help your client in arriving at a sort of understanding as to whether they want to file a Section 9 petition or not. One of them could actually be to run a quick search of the NCLT and NCLAT websites to see that, is there any sort of corporate insolvency resolution process that has been filed against the counterparty. What is that stage? Is there a likelihood that the CIRP process kicks in? If that is so, then you may want to consider moving the court very soon to try and ensure that your claim is secured prior to any insolvency actually kicking in against the other party. Once insolvency kicks in, of course, there is a moratorium, and then that becomes a sort of debatable issue as to whether an arbitration proceedings can even continue or will they remain in abeyance. Now, in a court of law, what happens practically? You go with your Section 9 petition, it's drafted and filed before a judge. Obviously, you move a precipice. A precipice is a written request to a court showing why there is an urgency in the matter. You file that precipice before the court. It's either by a process of filing it before the court associate, or there is another process of mentioning a matter before the judge. Mentioning would involve you going very early to the court just before the actual matters are taken up, and usually done by a junior lawyer who would inform the judge that there is an urgency in this matter, kindly list it on XYZ date. Once all of this is done and the matter comes up for hearing, at the hearing, you will have to show the judge that there is a grave urgency in the matter. What are you seeking from the court? And then support your arguments, of course, with case law, etc. It is very often the case now that judges view Section 9 petitions as sort of documents where parties have just filed them for the heck of filing them. And what they end up doing is that they tell the party that, you filed the Section 9 petition. It really has no bearing before me. There's no urgency in this matter as such. It can be taken up before the arbitrator itself. And the reason for this is that after the 2015 amendment, Section 9 and Section 17 have both been brought on par. An arbitrator can award the same reliefs that a court can, and therefore really the scope of interference at a Section 9 stage from a court is very, very, very limited. Therefore, courts may not grant Section 9 reliefs as much now as they would earlier. There are also instances where parties go to and file Section 9 petitions to actually have the arbitral tribunal constituted. Because there are lots of judges, Bombay High Court is renowned for this, and it's a good thing that in a Section 9 petition itself, the judge will ask the parties, who do you want to appoint as the arbitrator? And the arbitrator will be appointed at the Section 9 stage itself. So there is no waiting for a Section 11 to be filed and then waiting for the 30 days and having a separate proceeding. It's all done within one composite proceeding. It saves on time and it saves on cost, making it efficient. Now, under the Act, an arbitrator or an arbitral tribunal has to be constituted 90 days after the Section 9 petition is disposed of. Given these practical solutions that judges have come up with, that 90-day period is not often followed, and you will find that the Section 9 petition itself is the starting point for the arbitration to commence, because then what happens is, in the Section 9 order, the judge would have observed saying that the arbitrator XYZ is appointed and the parties have to now take steps to constitute the tribunal, inform the arbitrator that he is appointed, seek his disclosure, etc., and then constitute the tribunal. Now, after this stage, what happens is that you will have a certain Section 9 petitions that are filed which may end up being frivolous, and judges come down quite heavily on parties filing frivolous Section 9 petitions. They don't entertain these petitions anymore. Earlier on, the whole concept under the Arbitration Act was slightly different. The approach was different. Now, there is a sense of business efficacy that is sort of built into the judicial system, where judges are also very, very restricted for time because there are so many matters that are filed, and they ensure that these petitions are disposed of quickly. The relevant petitions are taken up, heard and disposed of, and the irrelevant ones are just disposed of simpliciter, and the parties are told that you appoint your arbitrator, go before the arbitrator. So what happens when parties are errant in following Section 9 orders that are passed by the court? What is the consequence of not following a Section 9 order that a court passes? Of course, contempt proceedings can be initiated. You can initiate contempt proceedings for any order not being followed. But in a Section 9, if you don't follow the order, it has several disastrous consequences for that party in the eventual arbitration proceedings. One such consequence could be that a court actually strikes off the defense completely of the party and doesn't even allow it to participate in the proceedings. It's not only the defense, they can't even participate in the proceedings. Essentially, what happens is, in such cases, I'll give you an instance. Suppose a party is asked to deposit a certain amount of money in court and they fail to do so. They try and make whatever submissions they have in this regard to say that, we were not able to because of our financial position, XYZ. The court doesn't buy it. Then what happens is, the other side may press to strike off the defense of this errant party completely. The court may strike off the defense and may just restrict the participation of the errant party to a physical presence to be recorded in the arbitration proceedings. They will not be able to then take out any applications under Section 16 objecting to the jurisdiction of the tribunal, or make any points which are substantive. All that they can do is to make points on a demurrer basis. A demurrer basis would be just to sort of object to a few things that the claimant would have, maybe even cross-examine the claimant on their witness and their evidence. But essentially, the role of the defense would then be so restricted that it is almost a certainty that the eventual award that is passed would be passed in favor of the claimant.